Rachel, thank you so much. A great report about a very sad case that we will also be covering here on Law and Crime. We are waiting for the live feed in both of those trials. But I want to break down a little bit more about this case and how can you get a jury to sit in this case, and what does it mean to be a jury member in this gang-related shooting? So joining me via Skype right now is jury consultant Alan Tuerkheimer. Alan, it's great to have you back here on Law and Crime.
Great to be here.
So I'm going to ask you the question, if you're sitting on a jury and you hear gang members and a 22-month-old baby boy that was gunned down, how do you get an impartial jury?
Well, it takes a lot of questioning, a lot of probing, and you really have to get at people's attitudes and get a sense of how comfortable they're going to be, how candid they're going to be in voir dire, because as you alluded to, there are people that just don't want to have anything to do with it. They hear about who the victim is and who the defendants are, and so there are a handful of people that are going to just not want to show up and render a judgment in this case. So you have to go through questioning, you have to use your strikes, and then evaluate very critically the people that are left standing, and then say to yourself, okay, they're here, I don't know if they want to be here, but just make sure that my mind is a fair shake of things.
But I feel like that might be easier said than done, especially when we saw yesterday the testimony of key gang members who were talking about the defendants, the beef between the 187 gang and the PCE gang. The minute the jurors hear that these two men are affiliated with gangs, and the minute they hear gang members speaking, I have two questions about that. One, do they have difficulty accepting the credibility of gang member witnesses, especially since some of them chose not to be photographed or videotaped because of fear of their safety? And two, the minute that these jurors are hearing about them as gang members, it's a terrible affiliation for them to be a part of. So again, I ask, what is it like for a juror in this case?
So I think you're right. The credibility estimation is maybe a notch or two lower to begin with, because the term gang just has such negative connotations. But there are people that maybe are a little familiar with gangs, maybe they know gangs, maybe they had a relative or have a relative, and so gang members become a little more humanized, a little more personalized, and so they're not necessarily going to start out thinking gang member equals lying, bad, horrible person. Now, for many people, in fact, the majority, that probably is what they do. So the defense has to be extra careful to make sure that jurors who seated the case don't have that attitude and don't think gang member equals no credibility. So you have that in terms of seating. Once you're seated and you hear a gang member, yes, the goal for the defense is to desensitize the jurors a little bit. At the beginning, and love gang members, so really don't exist to deal with.
Yeah,
hear the term gang member.
Alan,
sure,
it's you mentioned desensitized. It's very hard to be desensitized, excuse me, in this kind of case when the jurors know about this young boy, 22-month-old Aiden McClendon, who was gunned down, and the minute they see a picture of him, it's hard. You're a juror, you're a human being. It's going to be very hard for them to sit on this jury. I'll say it right now. It would be hard for anybody. But we'll talk more about this case in a minute, and we'll talk more about our other live trial of the day. But before we get into either of them, here are the top crime stories of the day here on Law and Crime. As always, Anthony, thank you so much. Great stories. You can go to lawandcrime.com to learn a little bit more about them, or stay right here because I want to talk a little bit more about that Floyd Mayweather Sr. case. And to help me explain what happened, joining me is criminal defense attorney Andell Brown. Mr. Brown, great to see you.
Great to see you, Jesse. How you doing this morning?
I'm doing good. I'm doing good. You know who's doing even better? Floyd Mayweather Jr.'s father. He just got acquitted. What happened here?
Well, first of all, can we give him his name? He's Floyd Mayweather Sr. He gave Jr. his name. Well, it looks like what happened here is that the judge, the finder of fact in this case, because they chose to go with a judge instead of a jury, decided that there wasn't enough evidence to support a conviction. It seems like the defense on Floyd Mayweather Sr.'s side was that this was a contrived story aimed at getting money from him. And it looks like the judge went with that, or that the state couldn't meet their burden. He was acquitted, and the Mayweather team remains undefeated.
You think this will affect Floyd Mayweather Jr. in any way? I know he's had his brush-ins with the law, but I'm curious, you know, look, he's a brand, he's an image, and anybody associated with him, including his father, who's a big part of his team, you think that'll affect his brand or his business at all?
Well, I think the Mayweather brand is solidified already. If it could withstand Floyd Mayweather Jr.'s own indiscretions and brushes with the law, I don't see why an acquittal on behalf of his father would affect his brand and keep the money team from moving forward and advancing.
Now, I got to ask you this. This trial took place in Nevada, in the Las Vegas region. I'm assuming anybody there knows the Mayweathers. So how do you get an impartial jury? I was talking to Alan Tuerkheimer a little bit about another case about that before, but this is also another one. So many people know the Mayweathers. You think it's difficult to get an impartial jury or people that don't know about the Mayweathers?
It may be, but you'll be surprised that there are a lot of people that just aren't tuned into these things, especially when his father is one step removed from being the celebrity in the limelight. I think you can find jurors that don't particularly know Floyd Mayweather Sr. or his son or are particularly interested in them. Unlike myself, most people are not there are a lot of people that may not be boxing fans.
Yeah, but it's interesting. I think he's transcending the sport in a way. I think a lot of people know him even beyond the realm of boxing. I don't know how many followers Floyd Mayweather has on Instagram. I am one of them. But, you know, it's interesting when we covered the Tiger Woods DUI a few months ago. It's just you have a guy who transcends the sport, so you got to be very careful, I assume, of anything that comes out into the media. I mean, look at Conor McGregor, you know, a guy who got $100 million in a fight, and then all of a sudden, look what happened to him.
Right. I mean, you're absolutely right, Jesse. The Mayweather brand is a global brand. People know it around the world. Floyd Mayweather Jr. draws the eyeballs anytime there's a boxing match. He's broken pay-per-view records. And you just mentioned the fight with Conor McGregor. This is a professional boxer that was able to bring in a big name from MMA and still break records with an unconventional fighter. So the brand is very big. But looking at this case, it appears that the court said he didn't do it. He's not guilty. They don't have the evidence, and they tossed that case out on its ear. So I think moving forward, the brand is going to be just fine. And I think Floyd Mayweather Jr., whatever his endeavors may be, I think some of us, maybe like yourself, who's a follower on Instagram, hope that he has another fight in him so that we can see a little bit more of the Floyd Mayweather show. But we don't know what it holds for the future, but I think his brand will remain intact, and I think he's going to keep moving forward with hard work and discipline, which is the motto that he's reiterated time and time again, and fighting fights, whether he's promoting other fighters or out there, you know, making noise about going into MMA. I think his brand will remain strong and the eyeballs will remain on him.
I agree with everything you said, except I don't know if I want him to do another fight. He went out so on top. I kind of want to leave it like that. I'd rather just watch him take trips all around the world on Instagram, but that's just me. Now, Andell, stand by because we have a lot to talk about. I loved your perspective on that case. Again, you can go to lawandcrime.com to learn a little bit about the cases that we talked about and some other big top stories of the day. But right now, I want to shift gears and talk about one of our live trials of the day. I talked about it at the beginning of the program. It's the case of Daniel Tate, who has been charged with the murder of Olivia McKay. We have a report about that case. Take a look.
Law&Crime now takes you inside the trial of the 2017 murder of a teenage girl underway in Wisconsin. 20-year-old Daniel Tate's accused of choking and drowning 17-year-old Olivia McKay in Lake Michigan. The two had met online. Tate's alleged to have arranged to meet McKay in a park in Kenosha County, Wisconsin, along with a friend. After Tate killed her, prosecutors say, Tate and his friend put Olivia's body in the trunk of her car and dumped it in a rural area. Much of the state's argument in charging Tate comes from a confession of that friend, high school senior Jamari Cook, who claims he was there when Tate met with McKay and watched him murder her. Cook's expected to testify for the state, but the defense says he's not credible. Prosecutors say the defendant, Tate, had a history of choking women during sex and may call 3 witnesses who claim Tate choked them during consensual sex. Daniel Tate's charged with first-degree intentional homicide, hiding a corpse, and taking a vehicle without consent. I'm Dan Abrams for Law&Crime.
Thank you. That was our very own Dan Abrams explaining that case that we will be covering here live. But there has been a very interesting wrinkle, a development in this case that I want to talk about right now with my guests, Andell Brown and Alan Tuerkheimer. But first, I want to bring on Alan because, Alan, this is what we just heard. There is speculation, we'll probably learn later on this morning, that two women came forward to say that they overheard two jurors talking in the bathroom. They said the jurors were saying that they were going to get the other jurors to agree with them. And then a third person came forward and told the judge not to believe the two people that said this. The judge is going to clear all this up this morning. But if it's true that you have two jurors who are conspiring in the middle of this case, what do you make of this? And you're a jury consultant. I mean, we got to make some sense of this. What's happening here?
Well, it is such a big temptation to talk about the case, even though jurors are instructed over and over not to. They're instructed not to make up their minds. But as we know, it happens. And the question is, what do you do from there? But it's really difficult. Jurors come in, they hear all this, they hear witnesses, they go through voir dire, they hear opening statements, and they go through a case, and they're supposed to just keep their mouth shut and not talk about the case. It's difficult. So there is a tendency, and we know jurors do talk to each other. The jurors do make up their minds, and this is a real problem. This is a mess, and it's unfortunate. It's good it came to light, but this is a problem, and it'll be interesting to see how it's dealt with.
Andell, how will it be dealt with if this is actually true?
Well, I think the judge is at some point will ask questions of those two women that observed or claimed to have observed whatever happened. And I think he's also going to investigate, or have the lawyers will also assist in investigating whether what they have to say is credible. Once it's kind of determined that there's some credibility to this allegation that these jurors have been discussing the case, then I think the next logical step is to ask those jurors questions or question other jurors about what they may have heard or seen to indicate whether or not this went on and to the extent which it went on, the degree to which it went on. Once that's figured out, I think the next logical question is, has this case been tainted by the actions of those jurors? And do we have to scrap everything and start over with a fresh set of jurors and a brand new trial?
The one thing I'm confused about, and maybe you can tell the viewers, this is either to Alan or Andell, I thought that, are people surprised that the regular people from the gallery can even be in interaction with the jurors? I thought the jurors would be sequestered in a way, but that's not in every case?
In the cases I've seen, they usually have separate accommodations. They have a separate bathroom. They have a separate room where they go to, so that we don't have the issue that we're having right now, where we have jurors intermingled with various people from the gallery, because we don't know who these people are. We don't know what their motives are. We don't know whose side they're on. They could be there to support one of the defendants and hoping to throw some type of chaos into the mix. So there's a lot to be concerned with. It sounds like someone wasn't following that type of protocol here.
And Alan, you were saying?
Yeah, a judge would usually tell a jury, don't talk to anybody. During this case, you might see people in the bathroom, you might see the attorneys, you might maybe use a separate elevator bank, but certainly a judge would tell the jury, if somebody does approach you or starts talking to you for any reason, let me know right away. So jurors should understand that that's what's expected of them, and typically they follow those instructions. I mean, yes, there's a temptation to talk and maybe transcend some of the rules that are set, but I think this is pretty unusual. Not only did sometimes jurors want to just talk about some aspect of the case, but it sounds like in this case they were talking about guilt and innocence, which is another step up the ladder.
Exactly. Well, there's a lot to talk about in this case, and I'm glad I have you both here, because what I want to do right now is play some of the testimony from Jamari Cook. This was the person that accompanied Mr. Tate to meet Olivia McKay the night that she died, and according to him, he was there when Tate killed her. Let's play some of his testimony right now. Welcome back to Law and Crime, everybody. That was Jamari Cook testifying against Daniel Tate in the murder case of Olivia McKay. Something, though, in my mind just doesn't add up. Let's bring back in Andell Brown and Alan Tuerkheimer. Andell, I want to start with you. Something doesn't seem right here, in the sense that, let's start off with the idea that, okay, Daniel Tate met this girl, Olivia McKay, online, obviously for a romantic interest, brings along his friend for the encounter, I find that bizarre starting from there.
It does sound very bizarre. I don't know a lot of 20-something-year-olds that bring along chaperones when they go on a date. So there's something amiss about this story, and I think the defense is going to seize on the irregularities here and say, look, they're telling you a story that doesn't make sense because they need a conviction. This guy is incredible. His story doesn't match up, and I don't think you should believe it. I think that's the defense perspective.
You mentioned the jury. You mentioned the defense picking up on that. They did. Yesterday, they were really keen on saying that, Mr. Cook, the statements that you made in court today are different than what you initially told investigators. So, Alan, when a jury, I'm sure you're sitting in a jury, you're waiting for someone to be tripped up, you're waiting for them to have an inconsistent statement, you're waiting for them to lie. The minute the defense puts into the minds of the jury that this guy has given inconsistent statements, and let alone he's not just any witness, but somebody who the defense is saying actually might have killed Olivia McKay, and he who himself has said was right there when she was killed, what is going on in the minds of the jury?
Sure. So it's going to vary. Some jurors are going to think, oh, this is a problem, and others are going to say, look, he's young, he's under pressure. Are these really that significant of inconsistent statements? But I think as a whole, certainly as prosecutors, you don't want this to happen, because jurors are going to take note of it, and it does start to put dents in the credibility of a very key witness.
That's true, and I'm wondering if this was more harm than good, but then again, they didn't have any choice. They have to put this witness up, and I want to continue playing some of his testimony. This is Jamari Cook when he describes the actual strangulation in detail. And what do you not hear? You don't hear him intervening. Let's take a look.
I'm going to come up.
Jamari Cook testifying against Daniel Tate. He was there the night that he allegedly killed Olivia McKay, but didn't do anything to intervene. Let's bring back in Andell Brown and Alan Tuerkheimer. Andell, I want to start with you. So he's there, sees them by the water, goes to listen to his music, sees him choking her, doesn't do anything at first, then turns around and he's dunking her head in the water, and that's when Jamari just said, I was stunned and I couldn't do anything. Now, the defense has been very big at pointing has been very strong at pointing the point that this guy, Jamari, is a much bigger individual than the defendant, could have jumped in but didn't. Does something not seem right about this part of his testimony?
I mean, Jesse, as I listen to the testimony, I just feel like there are inconsistencies. There are things that just don't make sense. He's not doing a very good job of telling the story. And I think, frankly, that the defense team, they missed a couple of opportunities to object to leading questions that I thought the prosecution was asking. Or I think there were certain points in Jamari's testimony where he just couldn't get his story together. It seemed like, oh, well, they were in the water, I saw him slam her, but I'm not sure he slammed her because I didn't really see him. I didn't see the slam. I just noticed her in the water. I figured there was a slam. There are a lot of issues that the prosecution is going to have to contend with coming from this particular witness. And the fact that he's much bigger than the defendant in this case, his reaction just doesn't seem to make sense. He sees all of this stuff happening, and not only does he not do anything to stop what anyone would do in his situation of murder, is that he helps put the body into a vehicle, into the trunk. He participates in the crime, which is another problematic issue for the prosecution.
Alan, I'm sure that when jurors sit in these kinds of trials, they may say to themselves, okay, let me put myself in the position of Jamari Cook. Okay, I'm out one night, I want to just be with my friend, okay, he's fooling around with some girl. I've been in situations where a friend is with another girl. Is it possible that he wanted to, they're saying, okay, that makes sense. Maybe I would have felt the same way if I saw him attacking this girl. I'm in utter shock, and my body is just doing things that my mind can't catch up with. I just start helping him because I don't want him to get in trouble, but I don't know what's really going on. Or are they sitting back and saying, this just doesn't make sense to me?
There's a certain amount of hindsight bias at play, and they are doing that. I'm sure that there are a handful of jurors saying, look, he's his friend, he was there to support him, he didn't know exactly what to do, and he just took it all in as opposed to intervening. Now, there's certainly holes in his testimony, but there were just two of them there, and she died there. She was strangled. She was underwater forcefully. So jurors, if someone else is testifying and the defense is going to try to blame Cook, then jurors are going to want an alternative theory of the case. Now, given the parameters, they might not get it. And if they don't get it, they might draw their own conclusions. But even though there are these inconsistencies, I'm not sure that's enough to make jurors think, well, there's enough doubt because I don't think Tate did this and maybe it was Cook. So he's doing the best that he can, but yes, there's certainly some hiccups along the way, but I'm not sure that's going to derail the prosecutor's case.
Well, let's play a little bit more of Jamari Cook's testimony. What we just heard where he left off is he helped put the body in the trunk. Let's find out what happened after. That's Jamari Cook, again testifying against Daniel Tate in the Olivia McKay murder case. So he says he was there that night, didn't do anything, but helped his friend to put the body in the trunk. Now, I want to bring back in Andell Brown and Alan Tuerkheimer. Start with you again, Andell. Now, the jury knows, and this is going to be evident more on cross-examination, that he provided inconsistent statements to the investigators from what he said in court. Again, it's not clear from his testimony when he first saw that there was a problem, why he didn't intervene, and why he helped his friend do this. I'm sure the idea is going out there that Daniel Tate and Jamari Cook talked about what they were going to do to Olivia before they even went out that night. Is that the impression you think that's being left in the minds of the jury?
I think, as you pointed out, Jesse, there are a lot of questions to be answered here. And I think one of the things the jurors would wonder is, well, you didn't know what you were getting into. There was no conversation before you got to this location. You guys are going to meet some girl that one of your friends met online, and you guys aren't talking about what's going to happen. I think there may have been some inclination of a plan. One of the things that Cook said was that it was about the car. So if these are friends, allegedly they spent almost every day together, there was a lot of trust between them. They had similar backgrounds. They had similar experiences at the time. They both had tumultuous home situations, and that's something that they bonded over. It seems like from being that close, there would be some discussion about what they were going to do that night.
Alan, is the jury sitting there thinking, okay, who actually killed Olivia McKay and who helped? Just because you excuse one party doesn't mean the other person's innocent. Perhaps they both had something to do with her death. I mean, what do you think they're going through as they listen to a person who not only was there, but helped dispose of the body, and now the defense put into the minds of the jury, this guy could have actually been the killer and not Daniel Tate?
A seed was certainly planted, and I think that's exactly what they wanted to do with this, the defense. And so some of the jurors are thinking that. Now, it's a question of how strongly they tend to think that way. They're not supposed to make up their minds till the end of the evidence, but sure, there's some that are maybe starting to wonder, what is Cook's involvement? And as Andell said, I think it's also kind of to put a counterpoint to that. They really trusted each other. These guys were very close. And I think one of the things that Cook said, I think it was quote, he said, "I was trying to help Daniel." Jurors pay attention to words that witnesses use, and I think that's pretty instructive. And I think that type of statement can do a lot to undercut the notion that, oh, he was bigger, he should have intervened, he should have done something. They were really close, and his really close friend was doing something that he probably thought that he shouldn't have. But there's an explanation for maybe why he didn't intervene. So it'll be interesting to see what they actually do with that. But for now, I think he's a good witness for the state, but there are some holes that are being punched in his testimony.
Following the Jamari Cook timeline of his statements, he first said he wasn't there, then he said he was there, then he said he didn't touch the body, then he said he did touch the body, and then he said that he didn't want his friend to get in trouble, so he didn't want him to, wanted to help him out. And then all of a sudden he hears that Tate is speaking to police, and then he speaks, and now what do we have? We have one friend testifying against the other. It's a pretty remarkable case, and we are going to cover it gavel to gavel here on Law and Crime. We are wait for the live feed. And then here's what we're going to do. We're going to take a quick break. When we come back, we have a lot more to discuss, not only in this case, but another case, the case out of Florida about that 22-month-old baby boy named Tate McClendon that was gunned down for gang-related violence. We'll take a quick break. We'll be right back. Thank you, as always, Rachel. Great report about this really sad case that we're covering. We're waiting for the live feed in the courtroom, and as soon as we have it, we'll make sure to go to it. Let's bring back in criminal defense attorney Andell Brown and jury consultant Alan Tuerkheimer to break down a little bit more of this case. Andell, I'll start with you. As you listen to this case, and you have these two men who have been implicated in these in a rival gang, and then yesterday we saw testimony from gang members, some of them who didn't want to be photographed or filmed because of a danger to them. What do you make about the prosecution's case so far?
Well, obviously, Jesse, as you touched on, this is a very tragic case. To lose such a young, innocent child to violence between two rival gangs. When you join a gang, you've pretty much resigned yourself to the fact that you're going to end up either dead or in jail. And to me, somehow you've acknowledged that you're okay with that. And these two groups of people that have engaged in this type of activity, they decide they want to go at it. But the problem is, what usually ends up happening is people that have not made that choice, that aren't involved in those types of activities, are the ones that end up getting hurt. And I think the prosecution's case here is focused on the culture of the gang, on the way that they move, on the different symbols that they use, and other things like that to help the jurors understand the background for this activity and why this all happened.
So, Alan, Kwame Richardson and Henry Hayes are both being tried in this case, but there are two separate juries, which makes it a very unique circumstance. Can you explain what that's like and why that's happening?
Yeah, I just think that a lot of times defendants are tried together, but they each, I believe they requested that they thought that one trial of one was going to spill over into the other, and there would be some undue bias, and that some information from one of the defendants would spill over and affect how jurors perceive the other. So it's not that common at all, at least from my understanding, and it involves a lot of logistical challenges for the court because you have to time it just right. So if one witness is done and then they have to maybe go to the other defendant's case and testify, then that defendant has to be ready for that witness, and there's probably another witness testifying. So it really mucks things up a little bit. It can be done, and it is being done, but there's certainly some challenges that are happening with it.
Well, we saw that with the testimony of Tamisha Brown, who is the mother of 22-month-old Aiden McClendon. When she testified, the Richardson jury was excused, and she pointed the finger at Mr. Hayes as being the shooter. I want to play some of her testimony from earlier in this case. It is very emotional. It is very sad, specifically because this is her recounting what happened to her baby boy on the day of the shooting. Let's play that testimony right now. That's Tamisha Brown, the mother of 22-month-old Aiden McClendon, testifying in the case against Kwame Richardson and Henry Hayes, the two men who have been accused of his murder. It's alleged that they engaged in a drive-by shooting. They were allegedly trying to kill Aiden's cousin when, sadly, Aiden was caught up in the crossfire. Let's bring back in Andell Brown and Alan Tuerkheimer. Alan, I'll start with you. The jury is listening to Tamisha Brown. How much do they hold on to a victim? Because she is a victim in this case. Her son, her baby boy, was taken. How much do they hold on to everything that she says? And how much do they, because the defense has been very keen in saying, well, you were in the middle of a shooting. How much did you remember? How much did you see? Are you sure you saw my clients? So again, the question becomes, how much do they rely on her and her credibility?
Yeah, that's a really good question. They're gonna, as they listen to her, they're just gonna have to decide for themselves how credible she is. And I think she comes off pretty credible, but they're also gonna factor in that this was a horrific incident that was taking place. So there's that going on. She's not testifying in a vacuum. She was under extremely stressful, horrific conditions. And so, yes, they want to find for her. I'm sure they're gonna like her, but they have to evaluate objectively how she is reiterating exactly what took place.
And Andell, what did you think of her as a witness? I mean, she started her testimony clearly by breaking down, crying, understandable, having to recount this, but how do you think she came off?
I think she came across credible, Jesse. And obviously, she's a sympathetic witness, having lost a child. And I think one of the things Alan touched on was that the jurors have to take into account the circumstances.
Andell, I think we're losing you a little bit on audio. We're going to work that out. In the meantime, I want to play a little bit more of the testimony of Tamisha Brown, and we'll jump back with Andell to get his perspective on her testimony. Again, this is the mother of that young boy that was killed in the crossfire of this gang-related shooting. Let's go. Welcome back, everybody. Again, that was the testimony of Tamisha Brown, the mother of 22-month-old Ada McClendon, who was gunned down way too early. It was taken way too early in his life from what seemed to be gang-related activities. There was a beef between the 187 gang and the PCE gang. The defendants Kwame Richardson and Henry Hayes are alleged to be part of the PCE gang and engaged in a drive-by shooting on 187 territory, and this young boy was gunned down in the crossfire. That's Tamisha Brown explaining what happened. Now, I want to start back with Andell Brown, criminal defense attorney. We got cut off before. Overall, how do you think her testimony was for the prosecution?
I think she did a very good job, Jesse. She comes across as very credible. She comes across as very confident in retaining and remembering the events of that day. She seems to answer questions in a very straightforward manner. She doesn't seem to be avoiding the issue or trying to craft answers based on what she thinks is good for one side or the other. She appears to just be addressing the issues as they come up. And I think she does a good job as a witness. I think there's some larger questions about the way the investigation was conducted and the suggestive nature of a one-person photo lineup, as well as the fact that there was a picture emailed, I think, by brothers or someone like that. I think the defense will raise those questions. But as far as her testimony, her demeanor, and the way she answered the questions, I think she did a great job.
Yeah, we saw flavors of that in another case that we're covering where there was questions in police investigation. Those two men that were charged with the killing of Jonathan Price, a Marine, the jury found them not guilty. Well, let me rephrase, they didn't convict them of that murder, and the question became of police tactics and the use of a lineup, whether it was too suggestive or not suggestive enough. And we'll talk a little bit more about that factor a little bit later on in the program. But I want to bring back on Alan Tuerkheimer, jury consultant. Alan, you know, when the defense opts to cross-examine the mother in this instance, or, you know, we also had an instance where we covered a case, the Donald Smith case, where the defense, under the direction of their client, chose not to cross-examine the mother of the young girl that was brutally raped and killed. The jury's sitting there and they see the defense is cross-examining the mother who just lost her 22-month-old baby boy. What does that do for them? What do you think is going through their minds as they see that? How does that affect their opinion overall?
They become pretty protective in that situation, and the defense just has to, my advice would be to tread lightly, and I think they know that, because anything that seems forceful or pushy, no matter what, even if there's some facts that they could get out that are going to help their case, it's the tone that the jury is going to really focus in on, and it could backfire if they're too aggressive in the cross-examination. Now, for defendants in a case like this, they certainly want, and I would hope that in the beginning, when they did voir dire the panel, they said, look, you can't let sympathy play a role in this. Well, obviously sympathy does play a role, but at least if you get that message across, then if something comes up and somebody makes an emotional-based argument deliberations, you might have one juror that says, look, we made a vow, we said we couldn't let sympathy enter in. So we talked about in the beginning, of course, this is a 22-month-old who was shot and killed. Desensitization happens gradually. So the first time jurors hear about this, of course, they're completely put off by it and appalled. But the 50th time they hear about it, it's a different scenario, and then they're more able to objectively evaluate a witness. So the cross-examination has to be delicate, and jurors are certainly sympathetic, but then it just becomes a question of the degree of sympathy.
It's hard to shut off. It's hard to shut off when you have this kind of victim. And we played the testimony of Tamisha Brown, but she was not the only person in that car that day. I'm going to play you the testimony right now of Mary Thomas. This is Ada McClendon's great-grandmother. This is the mother of Tamisha Brown. I want to play you her testimony, her very emotional testimony about what happened when Aiden was shot. Take a look. Okay, I think that judge is handling other docket matters right now, reaming someone out for arriving late. Typical. All happens a lot. So here's what we're going to do. I want to talk a little bit more about what is happening with the juries, with the jurors here. Let me bring back in Andell Brown, criminal defense attorney. So could this have been an issue of a mistrial if you have jurors who are doing something improperly, or do you just replace them?
You're going to have to do a mistrial if that's the case, because the jury has been tainted at this point. We don't know to what extent it has gone. From the testimony I've heard, Jesse, I'm not sure exactly what they were talking about. When they say get the jurors on our side, they could be saying whether they want to get Italian or Chinese for lunch. So I really don't know what they're specifically talking about, and I guess that's what the judge as well as the attorneys are trying to figure out. What specifically are they talking about, and to what extent did this conversation go? That's what they're looking into. But I think if you have two jurors who have conspired in some form or fashion to try to decide the case or try to win other jurors over to a position they've already determined before the case is even over, that's obviously problematic. And those jurors should be dismissed. And in most cases where you're not dealing with, for instance, a whole lot of jurors, you don't have that many alternates, so they're not easily replaced. I think you're going to have to end up starting the whole trial over if it's found that what these jurors did rises to the level where mistrial is the only proper remedy.
It seems right now that the judge is not too concerned with this, but Alan, I'm here with Alan Tuerkheimer as well, jury consultant. When you sit on a jury, do you try to, I mean, these are all strangers. Do you try to develop a relationship early on with other jurors? Are they supposed to talk to each other about the case, or are they supposed to wait till they deliberate finally at the end? I mean, how difficult is that from a practical point of view?
It's very difficult, but look, alliances are formed, people form friendships, bonds are made, and it usually has to do with anything other than the case. People talk about, like Andell said, about their lunch, about things going on in the community, the weather, anything like that. So certainly the beginning of deliberations and the bonds and alliances that are going to take place during the trial, but they're not supposed to talk about the case. They're not supposed to mind it. It seems like nobody wants to.
It's not easy. It's not easy sitting on a jury, and let alone what the case is. So as the jury, speaking of which, as this jury is being brought in right now, I want to play a quick recap. I want to play a report about this case in case anybody has missed it. So this is the Daniel Tate case, the man who has been charged with the murder of Olivia McKay. Take a look. That is some live testimony in the Daniel Tate case, the man who's charged with the murder of Olivia McKay. We're going to jump back in a minute, but before we do, I want to sign off my very special guest for this morning, criminal defense attorney Andell Brown and jury consultant Alan Tuerkheimer. Gentlemen, it was great to have you both here on the program.
Great being here, Jesse.
Thanks for having me.
Have a great day, guys. We can't wait to have you back. All right, we are going to jump back now into that courtroom again. Detective Jason Kennedy from the Kenosha Police Department is live. He is testifying. Let's go.